Hello from Düsseldorf and welcome to all of you from all over the world. My name is Timur Kurt and I'm a project manager at NRW Global Business. I will guide you today throughout the program, which is a part of the Startup Tour 2021, which is organized by the Chamber of Commerce and Industry of North Rhine-Westphalia. So we are really honored to host this exciting webinar about the legal framework in Germany. And we hope to provide you all the necessary information about taxes, the company forms, and many more for you to start up your business in Germany and in a vibrant environment like North Rhine-Westphalia. But before digging into the topic, I would like to mention three technical aspects. First, I would ask you to mute your microphone in order to ensure a smooth process in our webinar. Secondly, the webinar will be recorded for future purposes, and we will gather your questions, which you can ask in the Q&A section, and we will ask them in the end to the experts. So now I will hand over the word to the project leaders, first to Mrs. Elena Matekina from NRW Global Business, then to Mrs. Nina Riga from the Ministry of Economic Affairs and Digitalization, and then to Mr. Nick Neidl. So welcome to you all again, and please, Mrs. Matekina, the stage is yours.
Thank you. Welcome on behalf of NRW Global Business. We are the state-owned trade investment agency of the German state of North Rhine-Westphalia. Our head office is in Düsseldorf, the capital city of North Rhine-Westphalia, and we have 17 representative offices in 10 countries worldwide. Our shareholders is the state of NRW, represented by the Ministry of Economic, Industry, Digitalization and Energy. Mrs. Riga is here today, thank you. Let me tell you very short about North Rhine-Westphalia or NRW. We are Germany's leading state in terms of GDP, number of international companies, industry and manufacturing, IT and software business, logistic, RID, and world markets leaders. NRW is one of the most popular investment locations for foreign companies in Europe, almost 20,000 international companies. The state of North of Germany's industrial heartland and place of global players. 18 of the 50 biggest companies, German biggest company, are based here, such as Bayer, Deutsche Post DHL, Deutsche Telekom, or ThyssenKrupp. NRW offers countless customers and cooperation partners for digital technologies and new ideas. And recently, the German Startup Monitor provide once again that NRW and especially of Rhine and Ruhr region are Germany hotspots for startups. Every 5 Germany startups comes from here. Get connect and explore the opportunities we offer to you here in NRW. Nina?
Okay, thank you very much. Well, a warm welcome also from the Ministry of Economic Affairs of the state of North Rhine-Westphalia. My name is Nina, and I'm happy to see that many startups from abroad are interested in the German market and especially in the state of North Rhine-Westphalia. Today in this webinar, I hope you will get all the information you need to know regarding the legal topic. That's why we have our experts here today with us. In case you're also interested in joining one of our great accelerator programs, you shouldn't miss another webinar on Monday that is hosted by the ministry. In this webinar, 7 programs will represent their offers for you, and you can get in touch with them afterwards very easily. So please don't hesitate and miss to register on the website. And now I hand over to Nick, I guess, from the Chamber of Commerce.
Yeah, thank you, Nina. Yeah, welcome everybody. My name is Nick Neidl from the Chamber of Industry and Commerce in the city of Dortmund. And I'm one of the main organizers of the Startup Germany tour. First of all, the Startup Germany tour is basically organized to give international startups from the InsurTech, the smart city and the logistics and mobility sector the opportunity to get deep insights into these sectors here in Germany. And it's a good way to connect with other startups and even with multinational companies from this region. As maybe of you already know, this Startup Germany tour will be again realized digitally. It will take place from November 14 to November 17 this year. But this tour is quite special because we will give 15 international startups the opportunity to travel to Germany to enjoy the Startup Germany tour on site here in the region of North Rhine-Westphalia. And wherefore we additionally organized from September 28 to October 7 in total 5 international startup contests, where the best startups from each participating country compete against each other and in a digital pitch competition in front of a professional jury. And the winners of these contests may then get exclusively access to the tours program on site here in Germany. And in the contest, you get exclusively insights about an international pitch competition. And furthermore, you get insights from an international startup that made it to Germany and from a German corporate about its national and international business. To get insights and to watch these contests on your screen, you as participants of today's webinar may register as spectators on our website, so the startupgermany.nrw, and so that you don't miss these interesting and exciting pitch contests. But today is the 7th webinar of our pre-program, and we would like to give you some information and content about the legal framework in Germany. But before I hand over to my colleagues, I want to thank the Ministry of Economic Affairs, Innovation, Digitalization, and Energy of the state of North Rhine-Westphalia and NRW Global Business for making this tour possible, by being partner of our Startup Germany tour and by being host of today's webinar. And therefore, I would like to hand over back to Mr. Kurt. Thank you very much and enjoy the webinar.
Thank you very much to all of you, Mrs. Riga, Mrs. Matakina, and Mr. Neidl, for this great welcoming words. And now I want to introduce the company which is providing the expertise for today's topic, the company Dentons Europe, represented by many experts. So I will hand over directly to Mr. Frank Tepper-Sawicki, who is a partner of Dentons, and he will introduce you to the program today. And yeah, I wish you a good webinar, and we hope you will benefit from.
Hello, everyone. Thank you very much for the nice introduction. I would like to welcome all of you from our side, Dentons, to today's webinar. I myself, I'm a lawyer in the field of corporate law, specializing in venture capital investments and a partner at Dentons in Düsseldorf. Dentons is the world's largest law firm and has also a group about a few important topics in the area of corporate law, tax law, and data protection that you should consider when you are entering the market, the German market, or even setting up a company. We will now start directly with Mr. Schinkel, who will take over the part on corporate law. We are now waiting for the slides, I guess.
Can you see them now?
Okay. So please start.
So good afternoon from my side as well. My name is Tim Schinkel. I'm an associate here in the Düsseldorf office of Dentons, and I work alongside Mr. Tepper-Sawicki in the corporate department. Today we will be speaking to you about corporate law aspects when it comes to establishing a company here in Germany. First up, we will have a look at the different legal forms that are available under German law. Then we will have a look at, is there only one choice? Can we choose different legal forms? And then we're going to look at some aspects that have to be considered, or that should be considered when setting up the company. Now, first, let's take a look at the various legal forms that are available to us when we want to set up a business here in Germany. Just for the sake of clarification, the legal forms you see on this slide, these are not all the legal forms you might encounter here in Germany, but these are the most common legal forms. So we can basically divide the legal forms into three broader groups. We have the partnerships on one hand, we have the corporations on the other, and then we have some hybrid forms. Now I will go over some key characteristics of some of those more common legal forms. First up, we have the partnership on the bottom left, the GBR. This is the most simple legal form we have on this slide. So this is typically a contractual permanent relationship between two or more partners in order to pursue a common goal. And this is characterized by the loyalty of its partners, and by the personal characteristic of the company. Next up, in a step up from the partnership, we have the general partnership, or the OHG. It basically shares a lot of the same characteristics as the partnership, but in this case, the common goal that is pursued has to be the operation of a commercial enterprise. And basically, like, the minimum that has to be there to be considered commercial enterprise is commercial accounting and bookkeeping. The last partnership we're going to look at real briefly is the limited partnership. Again, as a partnership, it shares a lot of the same characteristics as the previous two. However, in this case, we have two different types of partners. We have the general partner, who is generally the partner who is managing the company. And then we have the limited partner, who's basically just contributing capital. And one of the main differences as well is that the general partner is unlimited personally liable, whereas the limited partner is only liable to the extent of his liability contribution. On the other hand, we have the corporations, which is the limited liability company, which is the entrepreneurial company. You can group these two together, basically. And then we have the stock corporation. For the GmbH and the UG, the key characteristics, one of the first ones is that they are separate, their own legal personality. So they are the subject to their own rights and obligations, and they're strictly set apart from the shareholders. Since they are their own their own separate legal personality, and they have their own corporate bodies, and the companies are managed by the corporate bodies, so not directly by the shareholders. And one of the other key characteristics is the limited liability of the shareholders. So there's no personal liability, generally speaking, for any of the shareholders. Where's the difference between the GmbH and the UG? The main difference is the minimum share capital that is required to set up the company. Now, for a GmbH, you have to come up with at least 25,000 euros. But for the UG, or the entrepreneurial company, you can establish a company already with just €1. Now, typically, you would probably not just stick to the €1, because in the commercial register, you can actually see how high the share capital is. And therefore, you want to signal to the market that you have some capital behind you. So you would typically go higher, but it is possible technically to set up a company with very low share capital. Then we have the stock corporation, or the AG. Again, as a corporation, it shares a lot of the same characteristics. So it has the same legal personality. Again, it's managed, or it has its own corporate bodies. In this case, it's a little bit different, but dualistic structure. So we have the management board and the supervisory board. The management board, it's in its name, is managing the company, and the supervisory board keeps the management board in check. Another key characteristic, or something that's more specific to the stock corporation, is the fact that it's very strictly regulated compared to the other forms, legal forms here on the slide. Now let's move on and let's look at some of the key difference between the partnerships and the corporations. I might have mentioned some of them previously, but let's just go over them again. Now for partnerships, when it comes to the formation, you need at least 2 persons. And this is because of the personal structure or the characteristic of this type of legal form. Whereas when you have a corporation, you can establish a corporation by yourself. You do not need somebody else by your side. With regard to the contractual relation that we talked about, when it comes to partnerships, this can be an oral contractual agreement. It doesn't have to be written. Whereas when you have a corporation, those articles of association, they have to be written and they have to be notarized. And this applies to every corporation. And as I said before, there's no minimum capital that has to be paid in or contributed to partnerships. And there's a little bit of a exception. Well, there's no minimum, but in the limited partnership, the limited partner or commanditist has to pay in a liability contribution. But again, there's no minimum that is required by law. Whereas with the corporations, you have a very strict set of rules when it comes to the share capital, when it comes to how much share capital is required, and when it comes to maintaining the share capital. Now for the formation as well, the registration with the commercial register is generally not mandatory for partnerships, and it is only declaratory, which means the corporation itself can exist without being registered with the commercial register. However, a corporation cannot. So there the registration with the commercial register is mandatory and constitutive. So it has to be registered to exist as such. Now, a difference is also when it comes to management. For partnerships, in principle, the partnership is managed by its partners. And the limited partnerships are a bit different, whereas only the general partner manages the company, but in general, it's the partners. Whereas for the corporations, it's the corporate bodies, and they can be either third parties, or in some cases, you can also use shareholders as the management, for the management. And the liability, as I said before, partnerships are usually personally unlimited liable. Partners are, but the partnership itself, which is only, again, a slight exception for the limited partnership, where the limited partner is only liable to its liability contribution. Whereas with corporations, there's basically a strict division between corporation and between the shareholders, and the shareholders are typically not personally liable for the liabilities of the company. Now that we have seen a few of the legal forms that are available to us, let's now have a look at what does that mean for in the practice. Do we have to always go with a corporation? Can we go for a partnership? What is the best option here? Let's first ask ourselves, why is the choice of legal form important? Now, the choice of legal form can have implications on quite a few important aspects, and one of the most important ones, I'd say at least, is the liability. As we've seen before, partnerships, personal liability, whereas corporations, we do not have that issue. The other thing is instructions. When you look at the GmbH or the AG, for GmbH, you can, as a shareholder, instruct your managing directors, whereas a stock corporation or AG, this is very limited. And there are some core aspects where the shareholders are responsible for, but for the most part, the management board is independent. And another aspect is cost and effort. As we've seen before, some legal forms do require quite a hefty or large share capital that has to be contributed upon the establishment, and where some do not require any at all. Another thing to keep in mind is investors. So at some point in the life of a startup, you probably want to involve investors to get some fresh capital. And investors, they probably favor some legal forms over others for their different disadvantages or advantages. And obviously, tax is also something that is subject to the legal form. So you would have to keep this into consideration as well. I'm not an expert on tax, so this is not something I will be able to speak to. Now let's look at the disadvantages and advantages of some of the companies. We can first group together the GBR, the OAG, and the KG. And one of the big advantages that we have no share capital requirement. So if you just want to start out and you do not have a lot of capital available to you, this is a great legal form to start out with. And the formation process is straightforward. As we said, you do not have to have a written agreement. It doesn't need to be notarized. You can just, as it says here, plug and play. You can start you can just go and set up a company. Basically, disadvantage, one of the biggest disadvantages, however, it's personal liability of the partners, with the slight exception of the limited partnership. And because of the this personal structure of the company, if you have only 2 partners, or you had more before and then some left, if there's only one left, the company is typically dissolved, because there can only ever be a partnership with 2 or more persons. And typically would name the company with the name of the partners, which might be a problem regarding the brand recognition, especially if you're just starting out. Now let's take a look at the GmbH and the UEG. As we said before, it's a separate legal person, and there's a strict division between the shareholders and the company. So any obligation typically is with the company, not with the shareholders. So you have this separation, which makes your life as a shareholder a bit easier. And the same is for the limited liability. You do not have to worry as much that you will be on the line with your personal assets, basically. It's very flexible, because the object of the company can basically be anything you want. So there's a high flexibility there. And as I said before, you can influence the management of the company pretty easily. So that's also very good. Disadvantages, cost. We've spoken about this before, 25,000 minimum for GmbH, €1, okay, for the UEG. However, as I said, you probably want to go higher. And the formation is more complex. You need a written agreement, and it has to be notarized. So that has to be kept in mind, because both typically you would consult a lawyer, and a notary also takes up costs. The AG we're still gonna look at as well. Again, separate legal person, it's a corporation, and limited liability applies here. However, the AG holds a higher level, I don't know if you can say really high level, but a very high level of trust and prestige. Why is that? Because the AG is very strictly regulated, and you have this high minimum of share capital that you have to contribute, which is €50,000. Again, but this again is a disadvantage. If you do not have that much capital to start out with, this might be a little bit too much. So you might want to choose a different legal form. Again, very complex corporation. You need a written agreement, has to be notarized. Another disadvantage is the so-called statutory stringency, oder Satzungsstrenge in German. This means that in comparison to GmbH, where you can basically write almost anything into the Articles of Association, for the AG, you can only go away or deviate from the statutory regulations if the law expressly allows you to do it. So this makes the drafting the Articles of Association a lot more complicated. And again, the AG is much more strictly regulated, so there is a lot of formal requirements that have to be fulfilled, which makes this a little bit less flexible in daily operations. As a conclusion, we can say that you should think about the choice of legal form early on. You can technically change the legal form of the company later on. However, this typically also incur costs, so you might want to think about this beforehand. And as we've seen, there's disadvantages and advantages to every legal form. So there's no one-size-fits-all solution. The best solution is always determined by each individual case. Typically, I guess the GmbH and the UG is the most attractive form because of the limited liability, and because investors typically like to favor this legal form a little bit more, because it is attractive due to the limited liability, and because you have the shares which do increase in value as the company becomes more successful. However, if you're a business that is very capital market oriented and you want to have an IPO exit at some point, then you probably want to go along, or you have to go to the lines of an AG, stock corporation, if you cannot set up a SA Société Europée, I hope I didn't butcher this name completely, or a limited partnership on stocks. I hope that's the right translation. Okay, now let's have a look at the time. I have some left. Now we have decided to set up a company. In this case, I'd say we have decided to go with a GmbH because it's the most well-rounded, I'd say, form, which covers a lot of bases. This is a sample timeline for the establishment of a German limited liability company. And this is a very straightforward. So there's no hiccups, there's no special occurrences that are taken into account here. And as you can see, the time frame is not that long. So you would technically I'd say 1.5 to 2 months for setting up the company. And typically you want to contact a lawyer and seek a lawyer's advice because you have to adapt the company to your specific needs. And to do this safely, I would advise to seek out a lawyer. He will prepare the required documents, the articles of association, the commercial register application, the powers of attorney. If you're coming from abroad, you will probably need a power of attorney, and you will need an affirmation of the managing director that he is indeed able to be appointed managing director. The lawyer will handle all of those aspects. And then we have the notary appointment at some point, notarization at some point, and the registration with the commercial register. This is the point when the company is does exist, starts to exist, basically. Let's look at some aspects to consider during the formation process. Now, one key aspect to consider is time. Some things take time. Now, the preparation of the documents certainly can take time, especially if you need your power of attorney legalized. Apostilled, this can take time, especially legalization can take a very long time. So this has to be taken in consideration beforehand. Registration with the commercial register can take time as well. If the commercial register is very busy, this can take time. Money is a thing you want to take into consideration. In addition to the raising of the share capital, you have to keep in mind you have notary costs, lawyer costs, registration costs, commercial register costs. They should amount to up to 5,000 euros for a very plain vanilla formation process. Then how do you want to structure your articles of association? Has to be considered as well. There's a statutory minimum, but besides that, you can add a lot more regulations to the articles of associations. This is something that would have to be discussed with your lawyer, and because this has to be tailored to your specific situation. And if there's foreign involvement, you also have to keep in mind that we need notarization, and notarization has to happen in front of a German notary. And so this means if you want to do it in person and you're coming from abroad, and you would have to travel to Germany, or you could always give power of attorney to your lawyer, and then he could handle the notarization for you. We have the aspect of legalization, apostillation. Legalization can take very long, 6 to 8 weeks, maybe longer. And apostille typically goes a bit faster. Then aspects to consider regarding the management of the company. Now, when it comes to who can act as managing director, you have a lot of leeway there. So it's very flexible. The law only contains various exclusion criteria. But this is like, have you been convicted of a criminal offense? Or are you underage, for example? Or and then there's some additional requirements by some very specific regulations in Germany, but those are typically nothing that prevents you from being appointed managing director. And if you want to not interfere with the day-to-day business of your managing director, because as I said, you can instruct them to carry out certain transactions. You can set up rules of procedure which give them a guideline, which is mandatory for them to adhere to, where you can have regulations like the allocation of departments. You can set certain legal transactions that require shareholder approval, and you can have certain regulations regarding the decision-making within the management, who has more votes when there's a deadlock situation, and so on. Now, at last, we're going to have a quick look at employee participation, which is especially interesting also when it comes to getting new talent into your company. There are different forms of employee participation, but the most common or the most advantageous for a startup is probably the virtual employee participation, or if also a virtual stock option program, which is basically a contractual obligation towards your employee, as opposed to a equity instrument like ESOP, which gives out shares of equity to the employee. And because it's not a share in the company, the virtual employee participation is more advantageous to you. So that's it from my side. I think I covered all my slides in a good amount of time. Thank you very much. And I'm going to hand over to my colleague, Dominic.
Many thanks, Tim. So I'm Dominic. I'm a tax partner here in the Düsseldorf office, and I would like to talk with you about the elephant in the room, meaning the German tax law. And I will focus on the taxation of the GmbH, as Tim kindly outlined. This is probably the most important legal form which is attractive for investments into Germany. So the overview about what I would like to explain is that I have three topics: the taxation of the current profits and losses, the financing of a corporate company of a GmbH, for example, and the new rules under German tax law with regard to employee stock option plans. So coming to the first topic. So Tim, could you please click again? So many thanks. So technically speaking, I'm not able to click here. So it's Tim who does this for me. Many thanks for this. So a German GmbH is subject to German corporate income tax, CIT. So this depends on the GmbH, which is obviously the case, having its seat and actual place of management in Germany. By opposite, it's of course also possible to do any German inbound business by using, for example, a foreign corporation, to the extent that this foreign corporation establishes a German permanent establishment. Then this PE would then also be subject to limited corporate income tax liability in Germany. So the CIT rate is 15.825%. In addition, we have a trade tax in Germany, and the trade tax depends on the seat of the, in principle, of the seat of the GmbH, in which municipality it is. So there are different rates of trade tax between 7% and 19%. For example, in Düsseldorf, we have a rate of 15.4%. So as a rule of thumb, the total tax burden is approximately 30% in total, meaning CIT and trade tax. So if the German GmbH makes a profit distribution to its shareholders, then this profit distribution is subject to German withholding tax at a rate of 26.375%. If you are a German, meaning a domestic shareholder, and if you're an individual, then you could benefit from a lump sum taxation, meaning that this flat tax rate is all you would have to pay on these dividend income. By contrast, if you own the shares and hold them in your German business, then your individual tax rate is decisive. However, the benefit would be that on the other hand, there is a 40% tax exemption, so that you would have to pay taxes on 60% of the dividend received, to the extent that these are business assets. If you're a German corporation and receive dividends from a subsidiary, then 95% of the dividend is tax exempt, meaning that in the end, 5% of the dividends received would be subject to, in total, I mentioned this before, 30% approximately, so that in the end, only 1.5% of the dividend received would be subject to German tax burden. So this is somehow quite attractive. If you're a foreign shareholder, meaning you will invest by using a foreign corporation into a German GmbH, then you would have, in principle, to bear the 26.375% withholding tax burden. However, depending on double tax treaties, or probably within Europe, depending on the parent subsidiary directive, it might be possible to reduce this withholding tax rate to 15%, usually under double tax treaties probably, or to even 0% under the parent subsidiary directive. However, and this is very important to know, we have in Germany really, to be honest, quite burdensome anti-avoidance rules. So it's not so easy. You have to prove to the tax authorities that the foreign company which invests into the German GmbH provides, for example, for a certain level of substance in order to be recognized and to be eligible to benefit from the tax treaty or from a parent subsidiary directive. Coming to the situation that, for example, we have a German company which has a loss. So in a startup situation, this is quite common. In the first couple of years, you would probably have to suffer some losses. Then for tax purposes, we have a system where on the one hand, we have tax loss carry backwards, and on the other hand, we have tax loss carry forwards. So a tax loss carry backwards can be used upon application only with regards to the year before the loss-making year. I will explain this in the example below in a second. On the other hand, the tax loss carry forward, and this is the good news, can be carried forward for an indefinite period. So there is no stop date, so to say. There are different amounts. So before COVID-19, it was possible under the German tax loss rules to carry back 1 million euro only, so to say. But this has changed due to COVID-19, so that for the years 2020 and 21, it is possible, if you have any loss there, to use a tax loss carry backwards to the year before, which may amount up to 10 million euros. So this will change, however, as from the next year, meaning that should you have or should you suffer any loss in 22, then it will again only be possible to use a tax loss carry backward of 1 million euros. On the other hand, with regards to tax loss carry forwards, we have so-called minimum taxation rules, which means that if you have any tax loss carry forwards, you cannot fully offset it against any profit. This is what I would like to explain in the example below. So the GmbH here shall be located and have its registered seat in Düsseldorf, where we have a trade tax rate of 15.4%. The example shall say that in the fiscal year 1, we have a profit of 80 million euros. This then triggers approximately CIT and trade tax in total of approximately 6 million euros. Then in the second year, we have a loss of, say, 50 million euros. Let's assume we are in the COVID-19 scenario. Then we are allowed to carry back out of this 50 million euros loss, 10 million euros back to the fiscal year 1, which would then have the effects that a tax refund of approximately 1.5 million euros would be paid, so to say, or refunded by the tax authorities to the company, so that the company would then have again cash in its pocket and probably get better out of this COVID-19 crisis. After the deduction of 10 million euros, the initial loss of 50 million is reduced to 5 million. So this 5 million euros could then be taken as tax loss carry forwards and can be carried forward to the fiscal year 3. Let's assume that there we have a profit of 4 million euros, for example. Tim, could you please click? This will then have the effect that under the minimum taxation rules, out of this 5 million tax loss carry forward, 2.8 million can be used to offset the profit of 4 million. So this 2.8 million euros is calculated by using 1 million to an unlimited extent, so to say. And afterwards, so 4 million euros profit minus 1 million makes 3 million. Afterwards, 60% of these 3 million euros would then lead to 1.8 million. So in total, we would have 2.8 million euros, which could be used in order to offset the profit of 4 million in the fiscal year 3. Then this has the result that only approximately 1.2 million would remain being liable to German CIT and trade tax, and would of course significantly reduce the German tax burden. So we had a tax loss carry forward of 5 million euros in fiscal year 2. 2.8 were used in fiscal year 3. So there is a remaining amount of 2.2 million euros, which could then be further carried forward to the next fiscal year 04 and so on. Next slide, please. So now we come to the question how to finance the German subsidiary. Of course, we have the common ways. Due to time reasons, I will focus here on the question, what is the impact if a shareholder loan is granted? Of course, there are other possibilities. So for example, of course, you can always finance a subsidiary by equity. On the other hand, there are also some fancy things like, for example, convertible loans and further things to think about. For the purpose of this presentation here, I would like, as mentioned before, to focus on shareholder loans. So if you have a shareholder loan, then the good news is if the German subsidiary pays interest on this shareholder loan to its foreign shareholder, this payment is not subject to German withholding taxes in principle. So this means that this is true and applies to the extent that the interest rate, which has to be paid under the shareholder loan, is in line with the arm's length principle, meaning that it is in line with a rate which typically also a third person would have to pay in case of, for example, a bank financing or similar things. Should the interest rate chosen under the shareholder loan exceed this market interest rate, then the exceeding parts could be qualified as a hidden profit distribution. And this has two impacts. One impact is that this exceeding part is subject to approximately 26% withholding tax. And on the other hand, this exceeding part of the interest payments would not be tax deductible. So how can this be avoided? We would highly recommend taking care by way of obtaining a transfer pricing study in order to be able to demonstrate to the tax authorities that the interest rate chosen for the shareholder loan is arm's length and can be defended in this way. I mentioned earlier that the interest payments under the shareholder loan are in principle, to the extent they are arm's length, not subject to withholding tax. On the other hand, if for example, the subsidiary in Germany as a GmbH would be financed by way of a silent partnership or by way of a profit participating loan, then these interest payable under these instruments would be subject to German withholding taxes. And there are also some other things which might need to be regarded. For example, if a loan granted is secured by way of German real estate, for example, by a mortgage, then this could also bring the German tax authorities in a position to issue an order to the borrower that he would have to withhold withholding taxes on behalf of the lender and to pay them to the tax office. Next slide, please. Thank you. Now coming to the German interest barrier rules, in a typical startup situation, this probably might not be of such importance at the beginning, because we have a 3 million euro threshold, meaning that any interest payments, irrespectively of whether these are payments to a bank or under a shareholder loan, together with any costs, would be fully tax deductible to the extent that this 3 million euro threshold is not reached. So this is a black-white scenario. If this 3 million threshold is reached, then the impact would be that all interest would then be subject to the interest barrier rules. And they say, in a nutshell, that in the end, only 30% of the EBITDA would be tax deductible. So if you do not have any positive EBITDA, this would then probably end up with no interest being tax deductible. However, then this would then have the impact that the non-deductible interest could at least be carried forward to the next year and probably then reduce the tax burden in the next year. Next slide, please. With regard to the German tax law, some new features were introduced for employee stock option plans. So typically we have the situation that from an employer's situation, the question is how to bind an employee, and in order to have a positive effect for both sides. And one way, of course, could be to establish an ESOP. And we have, of course, to bear in mind tax aspects. So these are what is the type of income, meaning what is under German tax law, the type of income. Is it wage income, which would be subject to the individual tax rate of the employee, or would it probably qualify as capital income? In this regards, then the flat tax regime would apply again, having this withholding tax rate, which I mentioned earlier, of 26.375%, which could be quite attractive, depending, of course, on the personal situation of the employee. The other question is, and this is quite crucial, so when is the taxable event? So when is the timing of the cash flow turns into being taxable and taxes have to be paid? And of course, also social security contributions also need to be taken into account. So what was the status quo before the law in Germany recently changed? So the status quo was, so for example, let's take the, could you please go back? Sorry, Tim? Yeah. So the status quo previously was that if you have an employee stock option plan, first of all, there is an option which needs to be granted to the employee. So the grant of the option itself is not a taxable event. Afterwards, if the employee receives shares, which he or she receives at a lower value than the fair market value, or probably the employee does not have to pay anything, then the question is, when does the taxable event take place? So under the previous German tax law, the taxable event was the acquisition date, meaning when the shares were booked in the depository of the employee. Then the consequence was that during the holding period, in case the company, the shares of which the employee owns, makes a distribution, then we would have 26.375% withholding tax again. So the usual principles apply. And should the employee then in the future somehow or somewhen get rid of the shares or have an exit scenario, then a capital gain, if any, would be subject to capital income tax. Again, it's the flat tax rate of approximately 26%, which is quite attractive compared to the individual tax rate. However, Tim, now it's your turn again. We have some new rules since the 1st July of this year, which I would like to explain now. Tim? Next one, please. Yeah. So we now have a tax deferral. So the idea is to avoid the so-called dry income situation, that an employee receives some shares, but does not receive any cash, so to say, in order to be able to pay his or her taxes, which would have been due before this new rule came into force. So this was partly abolished in a good way, at least with regard to taxes. With regard to taxes, we are now in a situation that at the acquisition date, meaning when the shares are booked in the depository of the employee, the taxable event takes place. However, the taxes are not due. So there is a tax deferral until the exit date, which could be triggered upon different potential options. So one could be that after a couple of years, the shares would be sold, or that the employee leaves the employer, or at least after 12 years. This means that at least for wage income tax purposes, the taxes would only be due and payable if one of these three events takes place. However, and this is unfortunately the sad story of this game here, is that for social security purposes, unfortunately, still social security contribution payments remain being due when the shares are granted to the employee. So this has not been aligned yet. We would hope that this would take place in the future. However, this is not quite clear. As you may know, we have elections in Germany in the next couple of weeks, and it's unclear what afterwards will happen, and if then a majority might be found in order to align also the social security contributions with the German wage tax law. Yeah, so I think, Tim. Yeah, many thanks. Sorry, one back. So this was not, this was also important. Yeah, so in the course of the tax reform, there's also a tax allowance which previously was 360 euros, and this has been increased to 1,440 euros. But this tax allowance only applies if, for example, and there are also some other conditions, if the employee stock option plan is offered really to all employees of this employer. So many thanks. Then I will now hand over to data protection.
Yes, hi Dominic, thank you very much for that interesting presentation. Hi everyone, it's a pleasure to meet you and a pleasure to be here today. And I want to talk about data protection law. But first, sorry, my name is Nico. I'm a senior associate with Dentons based in the Düsseldorf office, and I'm a member of the corporate compliance team and have a main focus on data protection law. So what I want to do is I want to talk to you about some data protection basics that should help you get at least an idea of the legal requirements and some potential pitfalls as well. So therefore, I would like to go quickly through some of the most important data protection basics. And afterwards, I would like to focus on two specific topics, as you can see on this slide here. Next one, please. Yes, okay, so as you can see, we have several sources of obligations for the data protection. The most important, of course, is the General Data Protection Regulation, which is the European framework for protection and as well processing data. And this is a very crucial point because the GDPR does not only prohibit any data processing, it also creates possibilities to process personal data in a way which could be very valuable for your company. We will talk about that later as well. Beside the GDPR, we have also the National Data Protection Acts. The EU members are free to enact supplementary acts in specific fields. So for example, the German legislator regulated the whole data processing in the context of employment law. So in case you're planning to create a German subsidiary and you will have some employees here, the processing of employee data must comply with the National German Data Protection Act and not solely with the General Data Protection Act. Not really comparable to written law, but just as important are the supervisory authorities, of course, because they can react with fines. So the compliance with GDPR and the National Data Protection Act is monitored by such authorities, of course. And these authorities also issue recommendations from time to time, which is, of course, not binding, but nevertheless, it is important to keep an eye on such recommendations to avoid any mistakes that could have been avoided easily. Next slide, please. Okay, here you see the two goals of the GDPR. The first one is pretty obvious. It's to protect the rights and freedoms of natural persons against unwanted processing of personal data. The GDPR provides strong rights for the data subjects and have clear principles regarding the data processing and of course, severe penalties for unlawful data processing. But the second one is more interesting in my opinion, because, and it's not very known, but still more interesting. The GDPR incorporates the so-called marketplace principle. And following to this principle, every company that offers its products or services to customers in the EU market must observe the GDPR as well, no matter where the company is actually based. So the GDPR aims to create a so-called level playing field for all companies acting on the European market, which has, of course, the aim to protect the domestic companies. So no matter whether your company will be in Florida, where the weather, of course, is nicer than here, I think that's the truth, or if you're based here in North Rhine-Westphalia in Düsseldorf, in case you're addressing the German or the European market, you have to observe the GDPR. Next one, please. Okay, this is one of my favorite slides and it's pretty short and I will go quick through it. What is and who is? What is personal data? It's pretty simple. It's basically any information relating to an identified or identifiable person. So something like your name, your email address, your phone number, but as well your height as well. So any data that could identify you. What is data processing? Literally everything you can do with personal data, from collecting to using to deletion, also anonymization. So basically everything you can do with data is relevant for the data protection law. Who is the data controller? This is the natural or legal person who determines the purposes for the data processing. So it's basically, or in general, it's that company that says what type of data we need for what specific purposes. And the data controller is also liable under GDPR for that very data processing. And last, who is the data subject? That's easy. It's the natural person whose data is processed. Let's have a look at the principles. The GDPR specifies certain principles that must be observed in all data processing activities. And I don't want to dig into deep to this right now. I just want to make sure that you have heard of these principles, since they must be observed in literally every data processing activity you will carry out with your company. Just want to mention a little, want to look a little closer is the processing principle of lawfulness. That's the first one. And we will have a closer look on this on the next slide. On the next slide. Thank you. So these are the 4 most important legal bases for data processing. So if you are processing personal data with your company, for example, from your employees or your customers, you have to observe, as said before, the principles, each principle, and you have to know on what legal basis you are processing personal data. You just cannot go anywhere and process personal data just because you think you need it or you may need it in future. No, you need a legal basis that allows you for processing of personal data for one very specific purpose. And yes, as said, these are the 4 main legal bases for private companies. It's consent, you all know that. It's contract, meaning if you need to process any personal data to perform a contract, then you're allowed to do it. It's legitimate interest. So in case your company has a specific interest which overrules the interest of the data subject, you may also be allowed to process that personal data without consent and without contract. And the last one is employee data processing, which allows you as an employer to process your employee data in case this is necessary to carry out the employment relationship. And as you can see easily on this slide, the principles and the lawfulness of processing are going hand in hand. So if you observe these 2 things, you have a pretty good chance to act GDPR compliant with regard to specific processings. Next one, please. So here we have that's an overview. That's just an overview, but it is an overview about the highlights, the highlight obligations under GDPR. So as a data controller, you have to appoint a data protection officer. If you have more than 20 people regularly process personal data in your company, or if you regularly or systematically monitor data subjects on a large scale. So much data monitoring, all that data processing activities that may be risky for data subjects require a data protection officer. As a controller, you also have to implement technical and organizational measures to protect and secure the personal data. We will talk about that later. And you have to maintain a record of processing activities, which is basically a list or an overview listing all the processing activities that are carried out by your company. And last on this slide is the obligation to inform data subjects. This is pretty common and pretty known. It's basically the privacy policy that you can find on every website. And yes, you have to provide such information to your customers or employees or everyone else whose data you are processing. So, and if you don't do that, we're coming to the fines. So in case you do not comply with the requirements of GDPR or the National Data Protection Act, the competent authority has several options to come after you, ranging from a simple warning, probably at the beginning, to the imposition of fines. And as you may already know, fines under GDPR can be very painful. So it's possible to have a fine of up to 20 million euro, or in case it is more than 20 million euro, of up to 4% of the worldwide turnover of the preceding year. And unfortunately, we have no catalog that prices specific violations of the law. So the amount of a specific fine is determined by the competent authority for each specific case, taking into consideration each individual case. So it's unfortunately not simply a business decision to risk an infringement. There is always a risk of a way too high fine. Okay, that was the run-up. And now we are starting with the first special. It's the cross-border data transfers. Data transfers to other companies are nowadays part of the daily business of almost every company. The data transfer does not even have to take place because of the company's own business model requires that. It's enough if the company stores data using a cloud service or uses software as a service product. In all that cases, companies are untechnically spoken transferring data to third parties. And this topic, you see that in the upper half of the slide, is especially interesting for you if you are planning to exchange or transfer personal data to other companies or companies, so external companies, or as well companies within your company group structure. If you're planning to set up a company group structure or already have one, which would mean that you are a very big startup, which would be great for you, I guess. So as you can see on the slide, we have to distinguish between data transfers from the EU, from a company which is based in the EU to another company which is also based in the EU, and a data transfer from a company which is based in the EU to another company which is not based in the EU. Tim, next slide, please. So, and as I said at the beginning, the GDPR does not only prohibit from any data processing, but also makes some things easier. Because since GDPR is applicable throughout Europe, data transfers between companies in the EU and the European Economic Area are more simple. So a data transfer, let's say from a company in Germany to a company in Italy or Spain, is, at least from a GDPR perspective, just the same as a data transfer between two German companies. So it's definitely easy to handle this. It is a little more complicated if you are planning to transfer data from the European Union to another company which is outside the European Union, because you have to make sure that the transferred data are protected at the same level as in the EU. And this is the case when either the EU Commission has issued an adequacy decision for the country the data recipient is based, or you take further measures to secure an adequate level of data protection. Next slide, please. So let's have a look at the adequacy decision first. What is an adequacy decision? It is basically a resolution by the EU Commission saying that the data protection law of a specific non-EU country is at the same protection level as the data protection law in Europe. So in other words, in that third country, personal data is protected by law just as good as it is in Europe. And in case an adequacy decision exists, a data transfer to a company in that country, based in that country, is treated basically like an intra-EU data transfer. So for example, I think Canada has partly an adequacy decision and Israel has a full adequacy decision. Japanese as well. So if a German company would transfer personal data to a company in Israel, it would be from a legal perspective, from a GDPR perspective, just the same as a data transfer to another German company. So next slide, please. In case an adequacy decision does not exist, data transfer is of course not prohibited in general. However, there are some more legal requirements that you have that have to be fulfilled then. In that case, the data controller, meaning you as a company, has to make sure that the data you're transferring outside the EU is appropriately secured. And this can be, for example, by concluding a specific contract with the data processor, meaning the data recipient in the other country. And this contract is called, it has a name. It's a special contract. It's called standard contractual clauses. And these standard contractual clauses are a standard contract form also issued by the EU Commission, and it sets out the responsibilities for a specific data transfer activity between two companies. And I have to mention this as well, sorry, pursuant to one of the latest decisions of the European Court of Justice, a data controller has also to take additional security measures to secure personal data when transferring it to a recipient in a third country. Such measures can be of technical nature, like the encryption of data before transferring the data to a cloud-based server, for example. And those measures aim to minimize the risk of unlawful processing by an unauthorized third party. So these further technical measures. For example, if we look at the US, where the authorities have the possibility, the legal possibility to process personal data from people in the union, you have to bring up measures against this unauthorized processing, because from a European point of view, it is an unauthorized processing. And now the next one. Okay, that's not far from data transfer security to data security in general, meaning data security in your company. When handling personal data in your company, you're obliged to maintain a certain level of data security. And this obligation has basically two separate levels. The first one, you can see it on the slide, is securing the company's data, so the data which is used, processed in your company. And the second one is the security for data which is used in products you may be creating. So it's the product compliance with GDPR. Let's go to level one. As a company, you have to make sure that all personal data that belong to your customers or your employees are protected appropriately by technical and organizational measures. Such measures, for example, are, so if you take an organizational measures, this could be, for example, ensuring confidentiality of those employees that are handling personal data of your customers or HR data in your company, by making employees signing a confidentiality agreement, for example. This would be a very common organizational measure here in Germany. It is not stipulated by GDPR. The GDPR does give rare examples for organizational or technical measures, but this is a very common one, and data protection experts are certainly able to help you in that regard if you're trying to search appropriately organizational and technical measures. A technical measure could be, for example, to avoid unauthorized deletion of personal data, or avoid physical access to personal data from any unauthorized third party. So it would definitely, or I would definitely consider it a data security breach if your company server, where all your company data is stored on, is placed in the office kitchen just next to the espresso bar and have an unlocked or free to use USB port. This would not be very good, and you would have to implement some technical measures to protect your data. So in that case, your server should be in a locked room, and the key should be not available to everyone. So just to the CEO probably, or the IT team. Let's have a look at level 2, the product compliance with GDPR. If you are offering certain products like software, apps, or similar, you must implement appropriate technical and organizational measures to make sure that the data of users are protected appropriately. So as well in your products, not only for the company data, but also in your products. And this requirement is called the data protection by design, meaning you must observe this principle already in the product design phase. So when you're creating your product, keep in mind that this product contains technical and organizational measures to secure the data. And besides that, a product must be designed in a way that by default, only strictly necessary data will be processed. And you guessed it, this requirement is called data protection by default. And be aware, a violation of these requirements may lead to a fine as well. And one important thing before I close, because I see time is running, you have to keep in mind that any careless handling of personal data and any data breach that could have been avoided with technical or organizational measures will have at least two consequences. The first one, I talked about it, is a potential regulatory action or an administrative fine. And the second one, and this is probably the more expensive in the end, is a damage of your company's reputation. And these are the takeaways. First, make sure to observe the principles of data processing. Make sure to observe the special requirements when transferring data. Make sure to observe data security requirements. And last but not least, make sure to let us know if we can be of any assistance. Thank you.
Okay, thank you very much. Mr. Schinkel, you may close the screen sharing now, then I can take over the word again. So, yes, thank you very much to all of the experts from Mr. Schinkel to Mr. Thoma and Mr. Winter for the great presentations. So I think the audience has a good understanding now about the German corporate law and the German tax law, as well as the data protection law. And we have some questions in the Q&A section. I think the first questions are addressed to Mr. Schinkel. If we can firstly register a partnership and then change it to a corporate company later on. Maybe you can answer it directly.
So I understand the question that if you started out as a partnership, a GBR or a OJG or limited partnership, and then later on you want to change your legal form. Yes, this is generally possible.
Also, tax aspects should be regarded. Yeah. So it is possible to do this in a tax neutral way, but then some conditions have to be met and some holding periods and things like this. So it's not straightforward, but it's of course possible.
Okay, so it comes along with some changes in different aspects as well. Okay, great. I have another question. I think also addressed to Mr. Schinkel. If it's possible to register a company from outside of Germany, so let's say the one is staying abroad and wants to establish a company in Germany. Is this possible?
So again, I understand you want to establish a company here, and you as a shareholder or as the founder, you want to stay abroad and you want to register the company here with the commercial register. Yes, this is possible. One would have to look into powers of attorney for doing so. For a GmbH, typically the managing director would have to register with the commercial register. So yeah, it is technically possible, but you have to put some thought into the process.
Okay. Yeah, the third and last question would be, is it possible to register a brand without registering a company? So this was a question in the Q&A section, so you might have a short answer to this as well.
So this is more of an intellectual property question, I'd say. I'm not an expert in this field. So
me neither, if I probably can help you, Tim. But it is possible, at least if you're having a representative here in Germany. So this would be no problem. But you would have to figure out whether you want to create a German brand or establish a German brand or a Europe-wide brand, because this could be, this could make sense if you are just starting in Germany and then trying to rule Europe.
Okay. Thanks for helping out. I think there's a great teamwork here. So, Mr. Thoma, there is a question. I have to admit, it's for me a bit complicated because of the tax aspects. Here's the question: is the same tax for GBR? Can you get something out of this question? I think as well. Now.
To be honest, I do not know for what GBR stands. Probably the one who asked the question could put another question in the Q&A.
I think it's GBR, so German GBR form.
Okay, if it's German GBR, okay, then it's okay. So as a general rule, a German partnership is transparent for income tax purposes. However, there's one exception. So German trade tax may also apply to German partnerships. But for CIT, meaning corporate income tax purposes and income tax purposes, a German partnership would be tax transparent, meaning would not be a taxpayer, but its partners.
Okay, thank you. Yeah, and here is a question: if it's possible to share some document or recommend a document to get these insights on a bit more simple way to understand. Is there any source you can recommend for the audience? I think, yeah, it has to, it needs some efforts to get all these things understanding. So
I think it is too complicated. It's a reality.
Yeah.
And we have such a record. You can show again, and if you have some concrete plain schedule or goal, you can every time connect, ask directly and be well connected or dialogue.
Okay, here is another interesting question. We have the case that if someone register a company in their own country, is it possible to work with this company in Germany? And they're asked for recommendation, is it better to work with this company or to set up a new German-based company?
It depends. Just I take over this question because I think that are questions that is really to the details and to the individual case, and you cannot say this in general. And it even makes a difference. Is it a EU country, a third-party country, or something else? So might not. We cannot give a such a general answer to it.
Okay.
And it even depends on what context, actually.
Yeah, so for further information, then they have to contact for the individual situation, then for advice. Okay. I see here a question for maybe Mr. Thoma. If a foreigner is located in Germany, will the domestic shareholder tax exemption still holds? How is it different from foreign shareholder tax reduction? I think this is a really specific question.
Probably the question deals with the question how a dividend payment would be taxed. So in this regard, I would like to answer it as follows. So there might be a small difference. So if you have a foreign shareholder which receives a dividend from a German GmbH, probably it goes also in another direction. So it's quite broad, to be honest. Yeah. So probably I'm thinking too complicated. Yeah, so there might be a difference, but it depends more or less on the specific circumstances of the case at hand. So as Frank initially said, it might make sense to probably directly contact us. And if we understand the question, if the answer takes, let's say, 5 minutes, we will not charge it. Yeah. And otherwise, we of course need to think about how to deal with this. Yeah. But of course, for us, this is a great opportunity here to show us and our team, and we are not out of the world after this presentation here.
Okay, that's good to know. Of course, for the audience, we hope that they will be in contact with you as well. So I will go through the questions. If there's something else here, if we formed a startup abroad, is it possible to migrate it to Germany in a form of GmbH? Is this a question for someone of you?
Within the European within the European Union, it would be possible, for example, to migrate and convert, for example, let's say a Luxembourg Saal into a German GmbH and vice versa, and also with regard to other European countries. Outside Europe, I think it would be an issue.
Okay, so it mainly depends from where you are from and from where you want to move the company. Okay. I think there are some more questions. I will pick 2 or 3 and then we will go ahead to the final. I want to open a German GbR and the service is for export. Can I have details of taxes and is there any support from Germany for the first year?
So speaking for taxes, so there is no support, so to say. So there is no subsidy or whatever from at least under German tax law, probably from elsewhere. However, a GbR, as mentioned before, is tax transparent. So in the end, the non-German shareholder partners of the GbR would be subject to German taxation. And if the GbR, for example, is trading, then the GbR itself would be subject to trade tax. As outlined before, approximately 15% of the profits would then be taxable in any case in Germany.
Okay, here's an interesting question maybe. For establishment of chain stores, which type of company is better? What for online shops? So is there any advice from your side or is it depending on the individual situation again?
From a corporate perspective, I don't think there's a general advice we can give as to what is the best legal form. It always depends on the individual situation.
Okay. Here's a question. Is it mandatory for newly registered companies to take a consultant or lawyer for dealing with tax issues in German tax offices?
No, it's not. But of course you should receive proper legal and tax legal advice in order to be able to make proper tax filings, because otherwise the one who signs the tax returns would be personally liable. And of course, it's not possible to say, look, I do not know the German tax law. I wasn't aware of this or that, so this would not work. So if you do business in Germany, you need to get familiar with it. So this is not only an answer for tax. So in any event, it's necessary to be compliant with regards to all things which are required.
Okay, thank you very much. Hope this will answer the question. So I'm searching for a last question.
So probably it's worth adding one sentence. So we do not have a system like in Luxembourg, for example. So in Luxembourg, you are required by law to have a so-called domiciliation agent. Otherwise, you're not able to incorporate a company. So this is not a system which we have in Germany. However, the effect should be the same as mentioned before. Of course, you need to be compliant with regard to all legal requirements.
Okay. Last for today, maybe the question on artificial intelligence apps. So here is a question, if there is any suggestion for data privacy to read for the European Union, or maybe Mr. Winter, if you see this question, can you give an answer to this? Because here is someone asking for a suggestion for data privacy.
Yeah, for further information. Is that correct? Okay.
Yeah, I think this is
okay, because I don't see the question. But if you are searching for further information in that regard, you can, of course, refer to our newsletter, which is published regularly. And of course, you can visit the website of the European Data Protection Board. That's EDPB. I don't know, search it via Google, and there you will find a lot of helpful guidelines and overviews that are explaining data protection also on a high level for beginners. And I think that is very useful. So go to EDPB or search it via Google. And yeah, I think you will find all the answers to the questions that you have there.
Okay, thank you. So I would now close the Q&A section, and thanks to all of you who shared their knowledge with the audience and also with us. Maybe before closing the session, I would hand over the words to Mr. Neidl again to close up, as he was responsible mainly for this event as well. So the word is for you now, Mr. Neidl.
Yeah, for all of you, thank you very much for participating at this webinar. Thanks a lot for you from Dentons. Thank you very much. And of course, thank you from the Ministry and NRW Global Business for hosting that today. Yeah, as I already mentioned, go to our website, Startup Germany Tour, and register for these highly recommended international startup contests. We would like to see you there to watch these interesting international startup contests, and yeah, hopefully we will have at least even more participants for next webinar on the 20th September. So thank you very much for all of you. Best luck, and see you soon. Thank you.
Thank you very much. And
thank you.
Wish all of you a happy evening. Bye-bye.
Thank you.
Thank you. Bye.
Bye-bye.